Good morning or good afternoon, everyone, depending on what part of the country you're from. Welcome to our CFIB member webinar as everybody kind of joins us. This is called Getting Paid on Time, Mastering Receivables Collection. And as we just let everybody come in the door, we're going to go over a few housekeeping items. This webinar has both a chat where you can converse with other participants, and we have a Q&A for questions. So please put your questions during the webinar in the Q&A section because the chat moves really quickly and we don't want to miss your question. And if you want to chat with other members, you can certainly do that there. We're going to be replying with questions both through text and live answer during the presentations. Not to forget this important part, all registrants, whether you're here live or you're watching this later, are going to receive a copy of the deck, and you're going to get a recording and a link to any tools mentioned in this deck tomorrow by email. My colleagues have also included a slide in the chat for you to download. Now, one of my favorite parts, I see a lot of you are already getting right to it. Go ahead and tell us what part of the country you're joining us from in the chat. It's always really fun to see that we really are coast to coast here. I see Ottawa, New Brunswick, Newfoundland, Alberta, Ontario. This is perfect. BC, that's great. We have a great webinar here for you today. We'll go to the next slide. I'm Jocelyn, the Senior Manager of Business Resources Initiatives, and I'm actually in Moncton, New Brunswick today. And today with me is Fernand Vartanian. He's the CEO of our legal partner of LawVo. He's joining us from the Toronto area, I believe. And along with us, we have some other CFIB staff in the background who are here to help moderate the chats and the Q&A. So let's take a look at the next slide, the agenda. Today's webinar, we're going to cover a brief reminder or an introduction of CFIB and LawVo's partnership, and then we're going to jump straight in the presentation about how to get paid on time. We're going to answer questions throughout, but there will be dedicated time for questions at the end, as usual. So next slide. So if you haven't met me yet on a webinar, I've been with CFIB for over 15 years, and one of our top wish list items for all of that time has always been to bring legal support to our members. And that's why we're really excited to remind all of you that members now have access to legal information, advice, and representation through CFIB's partnership with LawVo. LawVo services support a variety of all legal topics for your business, including employee management, corporate law, regulatory requirements, business contracts, and more. So let's take a look at the next slide and how we can access LawVo. The best way to access the legal suite of services is by simply calling us here at CFIB. Our advisors are going to help you with your inquiry, and we're going to make sure you're getting the right level of legal service. And sometimes that could be as simple as sharing legal information directly with you about laws and compliance. Sometimes that could be referring you to a LawVo lawyer to answer a question or give a piece of advice on a simple legal item. That's included in your membership. And finally, if a lawyer needs to do some work for you, we can set up a meet and greet where you can discuss proposed legal services and pricing for that work. And if you decide to hire that lawyer, you'll receive a 25% off on their regular legal fees. So why are we here today? Let's look at the next slide. Well, we're here because every dollar counts. What we've heard from you is that operational costs and uncertainty over economic conditions are making it very difficult to do business. We know that you're dealing with crushing taxes and tariffs, global supply chain issues and interruptions. Now there's strikes, more. Collecting all of the money that's owed to you is more important than ever. So let's look at some survey data. The next slide. As of September 2025, so very recently, our monthly business barometer, which is where our members, you tell us how you're feeling about running your business, shows that 27% of you had worse than normal account receivables. That means that 20% of you, 27% of you, or a third of you, have more money owed to you now than typically. And that's why we wanted to bring LawVo in to give you some great advice on how you can make sure you're getting paid on time from all of those receivables. So let's welcome in Fernand. Fernand, welcome. And I'm going to let you say hello and take it over from here.
Thank you. Thank you so much for that intro. Hi, everyone. I'm Fernand Vartanian, and I am the CEO of LawVo and a proud partner with the CFIB. I've had a chance to speak to many members, and we're so excited to be here today with you and to continue this partnership and to ensure that we are here for you in terms of support. In terms of a background, I'm a lawyer by training. I got into entrepreneurialism, and this is one of the companies that we started. But this is the most nearest and dearest to my heart. And CFIB as our partner is one of the most dearest and nearest to my heart as well. And I'll get into why that is as a personal anecdote. Fernand Vartan, as I said, those letters and behind my name are just to confuse people even further than my last name. It's complicated, so I just do that to confuse people. I'm just Fernand, but it's an important topic. We're here today to discuss because it's such an important aspect of business. If you don't get paid, you're not in business. So that's what we want to discuss today. Next slide. So before I start, I want to share a personal anecdote. So my dad was an entrepreneur for many years. Over 30 years, he was an entrepreneur. And his way of doing business was to shake someone's hand and say, okay, I'm going to give you this, and then you can give me X. And that was it. That worked for a while. And unfortunately, there were many instances where my father was not able to collect because, the handshake deal, for some reason over the years, just sort of didn't, bind anyone. And people had to move to a more sort of written form of invoices and things of that nature. My dad never believed in that. But then again, times have changed. And today is important because what we're going to show you is how to ensure that you actually get paid, not only paid, but paid on time. So why is it important? So we took some statistics from the BDC, and it looks like it's taking about 52 days on average to be paid. So I don't know about you, but you can't run a business if you're not getting paid relatively quickly because you have expenses and things of that nature. And unfortunately, the 52 days on average is above the healthy 30 sort of day benchmark that the BDC has sort of put out there. And then when you do wait, it's going to impact your payroll and staffing, supplier and financing costs, and growth and resilience. You, in essence, if you don't get paid, you're like almost like a bank. You're just, waiting to get paid. So we don't want that. So the bottom line, debt recovery isn't just about chasing money. It's about safeguarding your business and giving you the peace of mind to ensure that your business can grow and be stable. Next slide. So these are the foundational steps to collection. If you're going to leave with one thing today, I would say prevention is the best medicine, right? And how do you prevent a situation from arising where you do not get paid? Well, it always starts with proactive planning. So what do we mean by that? So you always have to have internally, you have to define what's an acceptable payment method and terms for yourself. Is it 15 days? Is it 7 days? Is it 30 days? Are you going to charge interest if it's more than 30 days? So you first have to determine, based on what your costs are, what is convenient for you. Sometimes 10 days works, sometimes 15, sometimes 30, sometimes 60. That you have to sort of set first and foremost. Once you make that determination based on your finances, you should implement policies and put those in writing. And I will explain to you why policies on payment terms is important from a legal perspective, and why you should have it in writing. Once that's done, train your staff. Make sure that the rules are applied consistently. So again, consistency is also key. We'll get into why consistency is key from a legal perspective as well. And then once you've done 1 to 4, you have to share those expectations with your clients upfront. So there's no misconceptions or any kind of mistakes. You have to have a meeting of the minds, if you will, with your clients. And the best way to do that, of course, is to have a written contract. Next slide. So receivables recovery, we have good, better, best. I almost hesitate to call the first one good. My father gave me one lesson. He said to me, good is the enemy of great, right? So I'm saying it's good, but I still would not recommend doing this. Invoice without protection. So what does this mean? You're just giving your clients an invoice with nothing else. It's just sort of, this is how much you're paying me, et cetera, et cetera. There's no clear terms and conditions on it, no payment terms, no interest. This is almost unenforceable if you want to go into court, because then it becomes a he said, she said, and then it becomes an issue of credibility, right? Who is the court or the judge going to believe? And you don't want to get into that 50-50 draw, right? You want some consistency and sort of predictability. Okay, so we said, even though we called it good, it's not actually good, right? It's the enemy of great. Just remember that. So we're going to say better. What's better than the first one? Okay, well, you have an invoice, but that invoice has some robust terms and conditions within it. So you can state the interest rate that you want, when is it due, what's the consequence if you don't pay it in time, clarifies the methods of payment. So is it check, is it EFT, is it credit card, what have you. And absent a contract, this gives you some legal footing, if you will, but most often than not, invoices are not signed. They're just an invoice. And then how do you prove that it's been delivered? And they can argue, well, I never actually got it, it was lost in the email, etc. So again, it's better than an invoice without protections, but it's not great. Then you have the best, written contract. Okay, written contract is always the Cadillac version of legal protection. You can tell I like Cadillacs, right? That's why I said Cadillac. So there you go. Why? Because it clearly outlines payment details and deadlines. It's legally binding and enforceable when it's signed, and provides the strongest position in case of a dispute, right? And they'll have other clauses in there, like an entire agreement clause, which says, this is it. There's no other verbal understanding or agreements. This contract governs the relationship. So then we have, like I said, good, better, best. So then the best, of course, is the written contract. Jocelyn, are we having any questions that we need to answer at this point, or should we continue?
Yeah, there's a few questions that are popping up. Just a reminder to all the participants, please put your questions in the Q&A. I actually saw a couple come up in the chat. There's one I'm going to hold from Liz just a little bit longer, but Angela's asking, is an electronic signature a legally binding way to sign these contracts, or is an email that says, yes, I will do this, enough of a contract?
Wow, that's a great question. Yeah, e-signatures are binding. Most if not all provinces have electronic signature legislation, which basically says that's why DocuSigns and things of that nature are electronic signatures. Wedding signatures are sort of going by the way of the dodo bird kind of thing, and electronic signatures are sufficient. An email wouldn't necessarily be considered an e-signature. It can help by saying the email acknowledges that they received the contract, but are they saying that they agreed to the terms? Do they not agree to the terms? You always want a signature on the contract. And the signature, as I said, can be e-signature or wet ink. But wet ink is not, more often than not, is not feasible this day and age. So e-signatures are perfectly acceptable.
Mhm.
Absolutely.
And Manny just followed up and wanted to know, what about text communication? Is that similar to emails, or is that a different?
No, the same thing again. Does it help? Great, but again, you can't basically commit to a contract by saying, "Hey, I agree to this contract." You need to have a signature because again, the text is saying I agree to the contract, but it's not referencing which contract, right?
Mhm.
You're going to have shrewd lawyers on the other side that are, going to make arguments or and things of that nature to basically get out of the predicament. Again, you know, you want to formalize things. Law is all about formalizing things. It's not informal, right? And so formalization always is about signatures and contracts. So I would try and avoid emails and e-signatures and sorry, emails and text messages, and really try and get contracts. Do the contracts, get them signed. That's your best option.
Okay. And along the same lines of what, since we're talking about contracts, Jessica's asking, because she's in the service industry,
Mhm.
and she said it's not ideal to send a contract before you kind of even have determined what the scope of work is. And so in that situation where things could change,
Mhm.
is there a better way to do that for service? Is
Yeah,
there
absolutely.
options that you could do?
Absolutely, absolutely. So whether it's a service or a widget manufacturing, so hardware or software or service, you can get into something called an LOI, letter of intent, or a memorandum of understanding, an MOU, which basically, and obviously we have those templates that can be used as part of the partnership with LawVo and CFIB. But yeah, absolutely, those are basically agreements to agree where it sets out sort of the high level parameters of your relationship. And then basically that gets replaced by a definitive agreement or a contract. So, absolutely, there's, like I said, LOIs or MOUs would be perfect in those industries where you don't have all the parameters set, but you have a sort of a skeletal understanding of, hey, this is how the deal is going to work. So then it's an LOI or an MOU that can be signed. Absolutely.
Okay, perfect. We have lots more questions, but I think some part of your presentation will answer them. So
Okay.
I'll let you carry on and then I'll jump back in a minute.
Perfect. And you'll occasionally see me having a coffee because it's like a coffee chat that we're having. And I'm hoping that you're having your afternoon coffee as well. So don't mind me and my little coffee cup here. So there you go. Next slide, please. Okay. We call this imperfect solution, right? So if for some reason you can't do a contract or it's just not feasible, then the imperfect solution would be an invoice essentials. So if that's the way you want to go, it's not perfect, as I said, but if you want to have an invoice, then you should have these elements within the invoice. So obviously the business and client details, legal names and address are important, right? Who is the entity that you are doing business with, the actual legal name. So often we see things where it's the wrong legal name or it's you use the individual's name and not the legal name. That causes some issues. So you want to make sure that you have the right legal name on the invoice. Obviously, invoice number and date. Dates are important. Invoice numbers are important because you want to make sure that you track, especially if it gets into litigation, that this was the right invoice, this was the invoice number, and we have multiple invoices with this individual, et cetera, et cetera. So, some degree of formality within your invoices. Have a description of the goods and services that you're providing. Payment terms, of course, due dates, interest and penalties for the late payment. Um, and then obviously authorized contact information, right? So ensure that the person that you're giving it to actually can or is the one that makes the decisions for that company, right? So they have either actual authority or something in law called ostensible authority, which I can explain later. And so you just got to make sure that you're dealing with the right person as well. That's why the authorized contact information is key. Next slide. Okay. As perfect can be. Nothing's completely 100% perfect, but this is as close to perfect as you can get. It's the written contract, right? Contracts are the first thing that a trier of fact or a judge will always say, where's the contract? Where is the contract that basically, in essence, shows the meeting of the minds of the service provider and the client, or the goods provider and the client? This governs everything, right? And the key to debt collection is formality. The more formality that you have, the better likelihood you have of collecting your debt. That's the number one key.
So along the same lines of contracts,
Yeah.
I've got a couple questions about POs, purchase orders.
Yeah.
So how does that play? Like, what if you get purchase orders from the client, and is a purchase order the same thing as a letter of intent? Are they different? Can you explain that?
No, absolutely. So I've seen purchase orders where you have the purchase order, but on the back, there's terms and conditions, right? So you can basically, in essence, say by purchasing the service or blah, 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 you acknowledge that you have read and understood the terms and conditions on the back of the purchase order. So I've seen people do that on invoices. So the first part's the invoice, but then on the back, you have the actual terms and conditions. So basically, what you're doing is you're saying, by purchasing this, you also accept the terms and conditions,
Mhm.
right? So absolutely, I would say a PO. PO is similar to an invoice, but a PO, I've seen the real good POs have like terms and conditions in the back, and so by the nature of you buying the service, you're already accepting the terms and conditions as well. And if you sign a PO, right, that can count as signature for the contract with terms and conditions in the back as well, right? Which is great.
Couple more questions about contracts. Very good questions. I love them. So Debbie wants to know, is it sufficient to have like a one-time signed contract at the if they're extending credit to a client, and they set up an account with terms, is that sufficient to cover all going forward invoices, or should they do it on a one-by-one basis?
Yeah. Yeah, these are really good questions, right? Awesome. I think you guys should have been lawyers, some of you. But so yeah, you can actually have one contract that governs all future invoices, but you got to make sure your contract says that, right? So this contract will apply for all future, services, blah, 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 in the time period. So you don't have to. I think it becomes really problematic. You guys are too busy to ensure that every time you sell something, you're going to get a contract. But if you do it properly, you can have one contract that governs the whole relationship. So every time you sell something, that one contract can be relied upon. Great question.
Okay. There's lots more. They're still coming in, but let's move on a little bit and then we'll come back to them.
Okie dokie. Next slide, please. Okay. We got some questions about interest rates, right? And what's the legal maximum, if you will? 60% annually is basically anything above that would become a criminal code violation. Um, I don't know anyone that charges 60%, so I don't even know where they got that number, but you can potentially charge that as interest annually. However, there's got to be business reasonableness as well, right? I've never seen that. This is like maybe a tier 3, tier 4 lender of last resort that can potentially do that. Sometimes you see sort of the payday loans companies that will be able to sort of charge something like that. But I don't think that, again, this is just my opinion, but from a fairness standpoint, and again, interest rates that you're going to charge also reflect how a judge will look at you if this ever goes to trial, because they're always looking at fairness as well, right? So if you actually have an interest rate charge of 60% annually, that's not going to reflect well on you, right? So you got to be reasonable in what you do. So industry practice is typically 1 to 2% per month, which goes to 12 to 24 annually. So again, be reasonable. I think interest is good to put in because it sort of acts as a deterrent for people. to actually, ensure that they pay, but you also want to be reasonable. And again, charging excessive or increased interest may not be enforceable, as we said. Like I said, at the end of the day, the people that are going to be looking and making decisions about potential litigation files are human, right? And they have their own, they're human. They have their own emotions and biases. So it's not like they're automatons where I'm just going to move. Just look at the black letter of the law. They're humans, and they're going to look at the reasonableness of your actions as well, vis-a-vis your clients. Next slide. Okay. Processes and tools. Remember I talked about consistency, guys. Consistency is so important. So number one, you got to keep consistent records of invoices, payments, and communications. Why? Because in the absence of, say, for some reason you didn't do a contract, or you lost the contract, or you didn't, you can't find it, or for some reason for this specific client you missed it. If you can show that you have a consistent process of doing something excellent, this is how I do it every time. These are my policies and procedures. In the absence of having formal documentation, your formal practices of consistent approach can actually help you in court, right? So you always want to have that. If you add consistency of approach to actually having a formal contract, you're golden, right? And that's what a lawyer is looking for, is can you prove that there's a consistent practice that you have and you have a contract, right? Before I get into the other bullet points, let's talk about the process of how you would go for debt collection. So the one thing that I will say, even though it didn't work for my dad, that he did that was really good as an entrepreneur, is he always had a conversation before he went into anything adversarial, right? Remember, there's that old adage, you can attract bees more with honey than vinegar. I think it does hold true here. I see it. So when we get clients coming to us and saying, I want you to issue a demand letter, well, the first thing we say to them, or sue this person, did you actually reach out and talk to them, right? And chances are they say no. And we've seen that when they actually go back and speak to them, person to person, human to human, that it does actually turn out beneficial. And I'll tell you why that's important as well from a litigation standpoint, if it ever gets to that point. So always start with a conversation or a very gentle reminder or a nudge, preferably written to them, or have a verbal conversation and then follow it up with an email, just saying it's a gentle nudge. If that doesn't work, then send out a formal demand letter, not from a lawyer, from yourself. Just again, reinforcing payment arrangements, and then put on your company letterhead. So that sort of shows an air of more formality, of more seriousness. And if that doesn't work, then I think you can, do a demand letter from a lawyer that really takes it into an adversarial component. And typically we see that that does the job. Not always, but a demand letter from a lawyer on a lawyer's letterhead does the job. So that's the process I would follow. Now, why is it important to sort of have that gentle approach in the beginning? So many times I've seen when we go to court that the first time the judge is going to ask, well, did you reach out to them and have a conversation before you sort of, spent a lot of time, energy, and cost and wasted the court's resources to come here? Did you actually reach out? And I'll tell you one thing, the court will look more favorably upon you if you say to them, Your Honor, I actually reached out, in a gentle way. These are the communications I sent, and there was no response. You're golden there, right? That really helps. So these are little tricks to their trade that, yeah, it's good to be nice, but you're also creating a nice foundation for an argumentation, a successful argument in court, if you can do that first step. Going back to the bullet points on my left side here. So every communication helps build proof of recovery, as we just talked about. Leverage your CFIB tools. They have access to you'll have access to some letters. You'll have access to some of our documents through your business representatives. And then again, follow the step-by-step escalation process consistently. Never jump to 3. Chances are you're not going to be successful, right? Start with 1, go to 2, then 3, and then you're off to the races. Next slide.
Yeah.
Oh, you have a question, Jocelyn?
Oh, yeah, we have a couple. And honestly, I think as you're right, often you won't have to get to three, but we always have some bad actors. And both Liz and Kelly are kind of in the position where the client, especially now during the mail strike, the clients are saying, well, come get your payment. They're not taking responsibility. They're putting the onus back on the business. Um, we have a few other members who are asking about what if the interest rate isn't a deterrent? Is interest something that you actually collect, or is it just used as a kind of a means of I don't want to say threat as currency to motivate them to pay? But then another member said it doesn't matter. Some clients are just not willing to play ball.
Yeah. So I'll tell you this. There's a lot of leverage you have if you follow the steps. So what are the steps? So in the third approach, when a demand letter is drafted, we typically in our demand letters will reference the fact that we will report them to the credit bureau, right? And that does severely impact. We see that making a big difference, right? Is when you sort of say, in addition to filing a statement of claim against you, we will also report you to the, various credit reporting agencies, and this will significantly impact your credit and your ability to do X, Y, and Z. So we will put that kind of language in. You can collect interest, and guess what? If you take them to court and you win, you can actually also collect a significant portion of your costs, your own lawyer's costs against the other party. So we also put that in the letter where we say, in addition to going after you for the amounts owed, we're going to go after you for the interest, and you may be liable for, costs in relation to this action. So not only do they have to pay the invoice, they have to pay the interest, they have to pay your lawyer's costs, plus they're going to get a negative rating on their credit report. Now, I'm going to anticipate a question because we get this all the time. Fernand, I spent all this money and I take him to court, but sometimes it's like getting water from a stone. They don't have money. Well, how am I going to, So there's something called is once you get a judgment against a person, you can enforce that judgment. So what does that mean? You can have an enforcement order where you can put a lien or a seizure order on their real or personal property. You can garnish their wages, and you can also discover them. So discovery is a process where you can actually compel them to come in front of, you can ask them questions like in a court where you can basically, discover them under oath about what their finances are and what their assets are. And then you can attach it. So you can make life very difficult for someone once you get a judgment against them to enforce that order. So it's almost like we indirectly, through our adversarial approach, educate the other side on why you do not, why you have to pay or why you should pay. It's in your best interest to pay because we're going to rain fire on you. That's why a lawyer comes in, you do all that. Typically, you'll get a good result. But again, that's the worst case scenario when you're bringing the lawyer in. But there's so many mechanisms that we can do to compel them to pay you.
Yeah, and I think if we move to the next slide, we're talking about what's beyond the demand letter.
Yes. So you have options for recovery, of course, right? You can always go to a collection agency. It can be quicker initially, but also I think the chances of success, the chances of collection are less. And typically what they will do is they'll only give you a fraction of what you wrote. So they might just buy your whole book of accounts receivables. And so you're not getting everything back. So it's almost like you get a percentage of the debt collected. And the unfortunate thing is once you do that, typically in the collection agency contracts that you sign, you cannot then subsequently sue the party because then it impacts their ability to do their job. So it's mutually exclusive. You can't do both in most instances. So the legal route, fortunately for some of you, it's quite high. So, I'm hopeful that you don't have outstanding invoices that are, approaching 100 grand. But for you in Alberta, you can actually go to small claims court and sue up to 100 grand. Ontario, as of today, it's 50. And then we have a slide. We'll show you the limits for other provinces. But Most of them fall within small claims court, and small claims court, the beautiful thing about small claims court, it's not as expensive from a legal perspective to pursue a claim as it would be in the normal superior courts, or the Queen's courts or King's courts of the various provinces. Small claims courts are much more favorable and more cost efficient. And I think that's what the purpose of small claims is to address these types of debt recovery claims. They don't want to make it unaffordable for fine folks like you to not be able to collect. So small claims is a very good way of doing it. In Quebec, there's a distinction. Civil law procedures differ than common law, which that can be explained by a lawyer to you. And then the judgment still needs to be enforced. Like I said, if they're not going to pay it, then liens and/or garnishments. You can do that. You have those abilities. So those are your two pretty much your only options, and they're mutually exclusive typically. Next slide. So here's the provincial and territorial small claims limits. You can see they're quite substantial, right? They go from a low of, what is it here, 15,000 to as high as 100. And that's a lot. I think there's a big sort of, I'm hopeful that your invoices, outstanding accounts receivable are not in excess of this. And then most of the time they fall within this, which makes it very cost, efficient. It's not cost prohibitive for you to pursue something in the small claims if that's what you want to do. Next slide. So just some legal and regulatory updates that I want you also to consider. Again, we just mentioned that as of today, it's 50K in Ontario. It used to be 35. Prior to that, it used to be 15. So you can see how small claims courts in the various jurisdictions are increasing it, understanding, of course, that there's more and more of these types of actions happening. Again, talk to lawyers or your BRs. There's certain prompt payment legislations depending on your jurisdiction and depending on the area of business that you're in, like the Construction Remedies Act in New Brunswick. So it's almost like you don't have to go through the court process. There's a statutory protections for you to get paid promptly. Like I said, particularly important in the construction sector so you can ensure payments down the supply chain. Limitations periods. I think I want to spend a little bit of time on this, cognizant of time. In most provinces, it's either 1 or 2 years. Again, depending on your province, you can ask your BR or the lawyer through LawVo. In essence, the limitation period says that you can only bring an action within a year or 2 years of when the actual amount is owed. Now, there's always questions about when does the limitation period commence. So the rule of thumb is it's not when the actual amount is owed, is when is the time that you can sort of say comfortably that all communication ceased and there's no prospect of getting the money. So if Jocelyn and I are going back and forth and Jocelyn's saying, hey, I'm going to pay it, give me 30 days, the limitation period doesn't start when me and Jocelyn are having a discussion. The limitation period starts when 30 days passes. Then she goes, can I have another 30 days? You give them another 30 days, and then there's no more contact. It starts at the point of the last point of contact with Jocelyn when there was no prospect of payment. So calculating a limitation period, I wouldn't recommend you do that yourself. Get your legal help on that regard, but just be cognizant that there are limitation periods in terms of when you can actually pursue a claim. Otherwise, you're basically time barred from doing so. Next slide. Okay, so key takeaways, guys. Prevention is the best medicine, right? We talked about this. So not only have a policy in place, formalize it, teach your employees and your staff, and also communicate it to your clients so there's a meeting of the minds. Consistency matters. In the absence of certain formal documents, if you can basically show that you have a consistent approach, month over month, day over day, year over year, that really helps you from a court perspective. Recovery options exist, as we talked about. So collection agencies, courts, and again, if water from a stone argument, if they're being very difficult, there are judgment processes that you can undertake in the various courts. and of course, CFIB and LawVo resources. We are here to help you, right? We know how hard it is for you guys to do your business. And if we can just help alleviate that to some degree and make sure you get paid, we're here for you. And I think that is it.
Yeah. Well, it isn't because we have 33 open questions. So you want to do some
Okay.
rapid fires? Okay. So do you have an example of what are standard payment terms these days? What is it? What's the typical standard payment terms?
Yeah, it's typically I see a lot of 50 to 30 after invoice, so invoice after receipt of invoice is 15 to 30 days
Okay.
payment terms. And that's reasonable. That's business. That's very reasonable. I don't see 7. I don't see due immediately upon receipt of invoice. I typically see 15 to 30. But then again, it depends on your industry, right? Construction is a little bit different construction industry because they have bills to pay downstream. Typically, they need to get paid quicker. So I will see 7, 5 days net, after receipt of invoice. I do see that.
Mm, perfect. Okay, so Steve has a great question. He works in transportation, and sometimes goods get lost, stolen, damaged, and that has partial or total losses. And the clients are responsible to pay according to terms and conditions, but that sometimes causes disputes. So when there's lost, stolen, damaged goods, how does that all come into play? How are we enforcing payments in those situations?
Again, it comes down to a good question. Again, it comes down to meeting of the minds, right? So typically, contracts will have clauses that say who is responsible for lost or stolen goods, right? And some companies say you can purchase insurance with the delivery, right? And if they decline it, that's on them. So, but it's again, that's where contracts come into play, or terms and conditions, where you can address these types of circumstances in terms of who's responsible. So you're still responsible, client, for lost or stolen goods, because typically their insurance provider would cover them in those instances, right? And so um, that's where, like I said, contracts come into play, and a meeting of the minds. It ensures that everyone's on the same page. So I would say in those instances, get a contract and then have a clause that addresses what happens with lost or stolen goods.
Perfect. And so for Darcy, she has a lot of contract-based business, and sometimes that business requires extensions. So she's asking, can there be clauses put into the contracts to allow for those extensions? It says regarding contract extensions where the customer is paid on completion of the project.
Yeah, so typically in contracts, there's clauses that say that if you don't enforce the contract, that it's still binding. Like you can't take someone's generosity, right, for an extension. You can't take someone's generosity against them in terms of enforcing the contract. As long as you have communication with someone that says, okay, you're getting an extension or there's an extension, but the contract still governs, that's fine. So in those instances, an email is great, an email or a text where it says, okay, we've agreed on an extension. However, the contract terms still apply, right? And there's typically a clause in every contract that says even if you deviate from the payment terms,
Mhm.
from a good faith standpoint, it doesn't impact your ability to enforce.
Okay. Crystal wants to know if it's okay to have auto renewing contracts if you have repeat customers.
Yes. Um, Again, it's industry specific, and auto renewals have to be fair and have to be brought up to the attention of the person, right? Because we've seen instances where if it's a hidden clause that auto renews for an additional 5 years with an escalation clause of 10% every year, we've seen courts determine that that's not enforceable, especially if the other side can show that it was never brought to their attention, right? And there's cases that have come out in the past at the Supreme Court of Canada, which said that there's an informal, even if it's not formally put in, there's an informal expectation of good faith amongst parties.
Mhm.
So you can have an auto renewal clause, but you have to make sure that that's been brought to their attention. I would even document that. Say, hey, we've talked about the contract. And we talked about that there's an auto renewal, that if you don't, that if you don't give us 30 days or 60 days, 60 days is a little more reasonable, cancellation request, that the contract will auto renew. As long as they're familiar with that and you brought that to their attention, it is enforceable.
Mhm. I there's a series of questions, one by Richard, one by Deneen, and basically it goes back to the customers trying to put the responsibility onto the business. So for example, Richard says, we've all been conditioned to click next, click next, click next. And then, you have clients saying, well, I don't understand what I signed. Is that a legal defense? And then, another question is that, well, customers want to pay on their terms, not my terms. Come pick up the mail because there's a strike. Uh, what do you do when the customer is trying to be the boss in this situation?
Yeah, let's address the first one in terms of, the next one.
Mhm.
So typically, we've given guidance to tech related companies or companies that are e-commerce based, where we basically say to them, and the contract is on the site that you're entering into. So typically they can't actually do anything unless they first have to scroll the whole contract. So it's not just a next. It won't let you go to the actual e-commerce site part where you actually can purchase anything until you actually scroll all the way down, and it says, by clicking here, you agree that you have read and understood the terms and conditions.
Mhm.
So you should have that. That typically is an e-commerce sort of situation. So, and we can give guidance on that, but typically that's what you have to do. And those have been found to be enforceable. If you scroll all the way down and you click that you've read and understood it, it's on you, right? It's on you as the person, because you've already acknowledged, but you have to have the evidence that they've clicked on it and said, I've read and understood, et cetera, et cetera. So you should always have a timestamp, for your site that sort of shows that, they did actually go down, click it, et cetera, et cetera. So that's how I would handle that. The second question in terms of, the clients pushing back,
Mhm.
that's where it comes down to, well, they can push back all they want. If you have a contract, the contract is what the contract is, right? That's the reason why you want formality, right? And now, can you deviate from the contract terms as a good faith gesture? Absolutely, as long as the contract has that clause that says, right, that, deviations from the contract from a good faith standpoint does not diminish the enforceability of this contract, then you can have that kind of conversation, right? But again, it's difficult to have those conversations in the absence of a contract, because listen, at the end of the day, you're businessmen and women, and you want to make sure that you have compassion towards your clients to some degree, especially in hard times. But you don't want that compassion or good faith to jeopardize your business or being paid. So have the contract, and then you can have those types of discussions where you sort of give them that leeway, if you will.
Mhm. Okay, we still have just as many as when we started.
Okay.
Okay, there's another a group of questions, and it has to do with when you go to court and you win. That doesn't mean you're guaranteed getting your money, right? So a couple of people are saying, like, is it true that even if I win, I might not get my money? And then we have another gentleman who does car rentals, and he says, I have judgments, but how do I go about enforcing judgments?
Yeah.
So these are two big ones.
Yeah, so we talked about that. So first of all, if someone doesn't pay judgment, they'd be in contempt of the court, right? The court's made an order. So that's number one. Number two, there's a process where you can enforce judgment, right? In terms of, as we said, you can basically go back to the court with your decision from the judge saying, I won the case, and you can basically then put, a writ or seizure or a lien on their personal or real property. That really handcuffs them, right? Because they can't do anything with it. So if they own a home, if they own some kind of property, you put a lien on that, or you try and get a writ seizure on it, they're going to pay, right? Because it's going to make their life miserable. They can't do anything if you have that kind of lien order on them. You can garnish wages potentially as well. And you can also have a discovery process where you can discover them on the assets that they own, and they're under oath and things of that nature. And if obviously if they lie, they're in contempt. And they'd be violation of the Courts of Justice Act, et cetera, et cetera. So there are means. Again, this is very rare. That happens when you get a judgment. Typically, in our experience, you get paid. In those some instances where you don't get paid, there are means to actually enforce judgment, and there are significant consequences against an individual legally if they do not pay. And so, like I said, that's a secondary step that you would have to follow after you sort of get judgment against them is the enforcement proceedings.
Yeah. I mean, I think Michelle actually brought up a good thing that we could talk about here. What about, at the beginning of the process, how do you feel about getting credit application forms? Doing a credit check, is that beneficial?
Right? Yeah, absolutely. It's beneficial to get sort of an understanding of their credit score, their business worthiness, or getting references. However, in some industries, I would say that you got to be, especially in the service side of it, you got to be careful because then there might be a violation of the Human Rights Code, right?
Mhm.
Where you're basically refusing service on the basis of some kind of you know a disability which has led to them having a poor credit score. Like that, I've seen those arguments made. So be careful there. That's why you need to sort of talk to lawyers when you're talking about refusing service. So just be careful there. But yeah, and in certain instances, you can absolutely. Landlords ask it all the time. Credit scores, right? From their renters. So I would definitely that's an option. But again, just be careful in the context that you're in that you don't violate some different law based on some kind of discrimination.
Mhm. So both Danny and Serge are kind of asking, like, as a business, how do you
Mhm.
actually report something against someone's credit report? They're to the credit bureau. How do you do that?
Yeah, absolutely. So just a clarification too, there's no credit check in BC, but that's so again, understand your provincial nuances, right? In terms of reporting it to the credit agency, so what's the first thing? I'm going to turn this back on you, Jocelyn. Let's have a little bit of a conversation. I'm going to quiz you now.
Okay.
What do you think the first thing that a credit reporting agency like Equifax is going to ask you when you say that they owe me money? And they say,
Oh,
what are they going to ask you for?
documentation.
Thank you.
Yeah.
So if you don't have a contract, good luck, right?
Hmm.
But if you have a contract and you have the invoice and things of that nature with all those terms that we talked about, that you can submit to them, right? And then that they're going to ask for proof, right? Because they can't just take your word for it because this is someone's livelihood or whatever that's impacting their credit score, right? So if you have the type of proof that you need, which is a contract, and you can show that they haven't paid, and they'll ask for other documentation, you can actually call and make a report on their credit, and then basically it's going to impact their credit score. And that, in my opinion, from my experience, that typically impacts people's. That's the biggest deterrent as I've seen because it impacts their score considerably.
Hmm. Hmm. I'm gonna ask Jennifer's question because I think in the mail strike it's pretty interesting. So she works in logistics, and there can be adjustment charges whenever there's special handling that comes up a few weeks after the shipment. And then the customers don't want to pay those extra kind of fees. So her situation is a little bit unique, but what are the best ways to collect those, any kind of fee or charges that come up after the transaction, the original transaction?
Yeah, so your contracts allow for that. So if you have a contract or terms and conditions, you can have clauses in there that say, your services or deliveries may, bring about extra surcharges or costs. And then you give a table of what these, so you typically what I see is an appendix of potential surcharges or extra charges or handling costs. And you can say these can be applicable, to you. And these will be communicated to you at the time, blah blah blah. So you can give yourself that leeway to sort of account for the fact that there's some extra ancillary charges, but you got to have a contract, right? You can't just sort of spin on that someone. It's very difficult to enforce that on someone after the fact unless you have a contract.
Perfect. So we're just looking at the time. We have about 5 minutes left. We're just going to finish a few more slides, and then we will try to get to a few more questions. So as part of this presentation in the deck, we're going to be giving you CFIB's invoice collection policy template. And this is a policy that you can implement to define what your consistent process is going to be, which is the most important thing of this whole discussion is consistency and a process. It's going to set expectations for your clients, your staff, and it's going to support legal compliance, which is exactly what we talked about today. And we're also going to send you a letter, a series of our collection letters, which you can use as your reminder and then your next step letter. In the deck, those teal blue titles, those are actually links, so you can open them through there and get them that way. So those are some tools that you could use to help you get started. And then wow, we still do have a lot of questions. Some of them are along the same lines, and then some of them are a little bit different here. There's a couple questions that deal with asking for deposits or retainers. Did you want to speak to that, Fernand?
Yeah, absolutely. Um, so you can ask for sort of some kind of a deposit, if you will, but then you have to address within that within the contract what happens with, like, if it's not used, or when is it returned, how is it returned, is it used for payment of the first invoice, last invoice. You just can't collect a deposit without telling them what you're going to do with it, or what the purpose of it is, right? And so it's absolutely available. You can do that in a contract, but you got to be clear with what its purpose is, right? Because there's consumer protection laws in the various provinces that talk about the proper way of doing deposits, where it can, where it can't be done, and what disclosures you need to make with respect to deposits, security deposits, things of that nature. So just be clear and articulate. You can do it. It differs from province to province based on the Consumer Protection Acts in those provinces. And that's why the BRs and the lawyers are here to help.
Okay, perfect. We do everyone, we do have a lot of open questions, and I think they're great questions. Some of them are very specific. I think what we're going to try to do is maybe amalgamate all of the questions we've answered live and the ones that are left, and come up with some means to get back to you. So please stay tuned for that. We have 3 minutes left, and Fernand, do you want to? Oh, we'll go to the next slide. Just a quick reminder to everyone, if you've enjoyed this webinar and you have another business friend, please always refer them to CFIB. We really appreciate your membership, and every voice counts in all of our fights. And finally, we will just say, thank you to Fernand. Do you have anything that you want to leave us with before we close up for the day?
Yeah, no, the only thing, I wish I could see all of you and all of your faces instead of you guys seeing this ugly mug. I wish I could see all of you. But know that, the CFIB and all of you are near and dear to my heart. I come from a family of entrepreneurs, and I wish you all great success. And the number one lesson is always make sure you get paid, right?
Mm.
And the way you do that is to have a formal contract, and use the CFIB resources and the LawVo resources. And again, I hope the best for everyone. Thank you so much for your time.
Yes, thank you everyone for joining us. We know it's tough out there, but we never give up. We never go away. We're constantly trying to bring you new resources and support. Thank you for giving us an hour of your time this afternoon. And if there is anything you need, always please give us a call at Business Resources. Our number's on the slide. And thank you so much. And with that, we will end the webinar.